The broadcast is now starting. All attendees are in listen-only mode.
Hello, and welcome to HDSA's Caregivers Corner webinar series. Today we're going to hear from Brooke Borg, who is going to discuss estate planning for Huntington's disease. Before I invite Brooke to begin, I'm going to go over how to ask a question, as well as how to access this webinar after broadcast. Brooke will be taking questions after her formal presentation, but you can ask a question at any time. You'll see the control panel on the side of your screen, and all you have to do to ask a question is type it in and hit send. This webinar will also be available for viewing approximately 1 week after broadcast. To view this webinar, you go to www.hdsa.org/ccorner. If you click on that link, you can download the presentation as well as a copy of the recording. You can also view all of our past Caregivers Corner presentations at that site. You can also find HDSA Lunch and Learn webinars by going to hdsa.org/ll. Now I'm going to give you a brief update of what we're going to hear in the next upcoming months. In July, we're going to hear about financial planning on July 23rd. In August, we're going to hear about driving cessation on August 20th. And in September, we're going to hear about long-term care for Huntington's disease on September 25th. If you receive emails from HDSA, you will receive emails about each of these webinars about a month in advance, so please stay tuned. And now I'm pleased to turn it over to Brooke Borg. Brooke established the Borg Law Group in 2010, and she practices in the areas of estate planning, probate, real estate law, and corporate law. Brooke earned her law degree from the William S. Boyd School of Law in Las Vegas, and she has nearly 12 years of experience in her field. She belongs to a number of professional associations and is a member of Business Networking International, and she's also presented at the Social Worker Professional Training at the HDSA Annual Convention in Las Vegas, Nevada. And now I'm pleased to turn it over to Brooke.
Thank you, Jane. Thank you, everyone, for joining us today. We are going to discuss estate planning concepts for individuals with HD and their families. And as was stated, I do represent clients in the areas of mainly estate planning and probate. My practice is in Las Vegas, Nevada. I'm originally from Michigan and have practiced there as well for a few years. And I really take a personal approach to helping clients. I really enjoy this type of law because you do feel at the end of the day like you actually help someone and you can see your work make a difference. I also practice in real estate law and corporate law as well. I am from Michigan, but I received my law degree from Boyd School of Law here at UNLV in Las Vegas. And I'm admitted to both the State Bar of Nevada and the State Bar of Michigan, as well as their local chapters. I'm a member of the State Bar Association of Nevada, Clark County Bar, the Probate and Trust section of Nevada State Bar, and then the City of North Las Vegas Chamber of Commerce and Henderson Chamber of Commerce. I am a solo practitioner. I'm the only attorney in my firm, but I do practice in the areas that we're going to speak about today and have done so for about almost 12 years now. So when we get into estate planning concepts, and we talk about traditional estate planning versus estate planning now. Traditionally, estate planning has focused on what happens after death. Usually people would come into the office and say, this is what I want to happen to my property when I pass away, and how do I do that? Now, because of changing circumstances in society and health and in a lot of legalities in the legal field as well as the medical field, families are realizing that the traditional methods of estate planning are failing them. And instead, they are looking for more of a holistic approach to estate planning. So now I get clients come into the office and say, we are concerned what happens to our property when we pass away, but we also have questions about other aspects of estate planning. Who's going to make medical decisions for me if I can't? Who will make financial decisions for me if I can't? Believe it or not, those are all forms of estate planning documents that are prepared and estate planning questions. So traditionally, the estate plan was a will and maybe a trust. Now estate planning encompasses medical powers of attorney, which we'll talk about, financial powers of attorney, and really how you manage your assets here while you're alive, and maybe dealing with a diagnosis such as Huntington's disease. That's a long-term illness, and that will affect your ability to care for your assets and control your assets while you're alive. So we're going to talk about that today as well. The importance of an estate plan, especially for families, nobody foresees their own death or diagnosis. I'm sure those on the webinar today or family members that have been dealing with someone that's been diagnosed with HD probably didn't even know what it was before the diagnosis. So who knows what's going to happen tomorrow? Nobody's promised tomorrow, and we don't know what's forthcoming. So estate planning is a way to prepare for the unexpected. And even the most agreeable families can become stressed when a diagnosis occurs or a death in the family occurs, and relationships are complicated. There may be a family member who hasn't accepted the diagnosis, or a family member that's in denial, or somebody who just doesn't understand the need to plan now for something that will happen in the future. So our goals today during the webinar is to, number one, better understand what an estate plan is. I know that many of you have heard terms like last will and testament, or living trust, or maybe even medical power of attorney. But an estate plan is really a combination of those documents that we'll talk about. Number two, we're going to talk about benefits to an HD patient and his or her family when an estate plan is put into place. And number three, we're going to discuss how smoothly a plan can be put into place for you or a family member if you don't currently have one. So what is an estate plan? A estate plan is actually a combination of documents, like I discussed, which sets forth your desires regarding distribution of your property upon your death, and it can also provide asset protection during your lifetime. So what I would like you to walk away from here today is knowing that an estate plan consists of many documents. And a lot of people will come into my office and say, well, I don't need an estate plan because I don't have an estate. Well, different states, I know we have listeners and we have people who are joining the webinar from all over the United States and I think Canada. And in a state laws differ from state to state. Here in Nevada, where I am, if you have over $20,000 in assets, those assets are subject to probate when you pass away. Probate is court involvement if you don't have a proper plan in place. So you may want to consult an attorney in your state, and definitely about an estate plan and what the rules are in your specific state. So some of the main documents that make up an estate plan are a living trust. Now there's many, many different kinds of trusts, and not one estate plan is right for every individual. That's why I would tend to shy away from those all-inclusive packages or the fly-by-night organizations that can prepare forms for you, because they really need to know a lot about your circumstances and your family situation before they suggest what documents are right for you. There are many different kinds of trusts. Probably for about 80% of my clients, I prepare what's called a revocable living trust. Revocable just means that it can be revoked after you enter into it. You can change your mind. The next day after you do it, you can decide you don't want a trust, and you can revoke it, act as if it never happened. With a revocable living trust, also, the grantors or the people who own the property that's going to be put into the trust, they have control over the property during their lifetime. So they can still manage the property just like they did if they didn't have it in a trust. Some of the main benefits of a living trust, a revocable living trust, is that it avoids probate. And probate, like I said before, is court involvement. So here in Nevada, if you pass away and you own anything more than in excess of $20,000 in your own name, and you don't have a trust, that will go through probate. And so you need to really take a look at how your assets are titled. Maybe you own a joint bank account with a son or daughter. If that's the case, when you pass away, your assets will go to that joint account holder. They wouldn't be subject to probate. So what we're talking about when we say avoid probate is anything that's in your name alone will be subject to the probate process unless you have a trust set up and it's owned by your trust. Along with a living trust, along with avoiding probate, there's also some tax planning that can go into preparing a revocable living trust, depending on how much your assets are worth. There's a certain amount that the government sets that you can give away tax-free at your death, and every year that changes. Last year that increased to, or the year before that, that increased to $5 million. So if you have over $5 million in assets, you're looking at paying some estate tax. If you don't, estate tax is probably not an issue for you. But that is supposed to be continued indefinitely, but we never know. We never know. So you should consult an attorney on a regular basis if you are concerned with some tax planning, as well as your CPA. A certificate of trust is a summary of your trust that sets forth who the main players of your trust are, who has control of the trust, and who's going to get your property after you pass away that's owned by the trust. The certificate of trust is nice because it provides a summary of your trust without getting into a lot of details. So after you prepare the trust, if maybe a bank or a financial advisor or another attorney asks for a copy of your trust, if you provide them with the certificate, which is a summary, that's usually sufficient. Along with the trust, you also are going to have what's called a pour-over will. This will, at least in Nevada, the will is the only thing that's publicly filed. So if you have a will and you have a trust as well, the will say that tell the court that you do have a trust and it's your desire for everything that you own to be dumped into the trust. This allows for an abbreviated type of probate, if you will. When we set up trusts for people, we always tell them you have to make sure that after we sign the trust document, you have to physically transfer all of your assets into the trust. This is a step that a lot of people miss. I see a lot of people that come to me and they have a trust set up, and the intent is that their trust owns all their property, so that when they pass away or something happens to them, the trust lives on and that property doesn't go through probate. But what a lot of people do, whether it be because their attorney didn't advise them or they just forgot about it, is they don't actually transfer those assets into the name of the trust. So for instance, if you owned rental properties or your house, and you have a living trust prepared, you want to actually prepare a transfer deed or have an attorney do a deed and file it that transfers that property from your name into your trust. That's what we call funding the trust. An interesting side story is that's why Michael Jackson's estate is currently in probate. They might have finalized it by now, but last I knew it was in probate. And you would think with all the advisors that he would have around him that somebody would have informed him, and maybe they did. I don't know the circumstances around it, but I do know that some of his estate went through probate because his trust wasn't completely funded. He owned some property in his individual name at his death, and that property was subject to probate. So it's very important to see an attorney to make sure that all of the I's are dotted and the T's are crossed after you sign the document. And things change too. We'll talk about this later, is when do you need to revise an estate plan if you already have one. So along with the will and the trust, you could also have what's called a living will or healthcare directive. This is only good while you're alive, and it gives direction on who can make medical decisions for you if you're unable to speak for yourself. As long as you can make medical decisions for yourself and tell the doctors and the nurses and the healthcare professionals what your wishes are, you can do that. But the moment when you become unable to make those decisions for yourself, whether you're in a state where you're unconscious, you are in a coma, you have Alzheimer's. I have an increasing number of patients who have come to me because their loved ones have Alzheimer's or dementia, and they become unable to make healthcare decisions for themselves. So what they do in that document is name someone to make medical decisions for them. Now within that document, you as the person signing that will state, these are my wishes. In Nevada, we have a specific form that's set by law, and it has 5 or 6 paragraphs that you have to read, and if you agree with those paragraphs, one's about life support if you're in a coma, one is about life support if you have a terminal illness, and you initial what your wishes and your desires are. So the person you name to make your decision has an idea of what you want, but they're actually the one that the doctors and the nurses turn to make those decisions. And keep in mind too, if you have any younger children or family members, anyone over 18 is considered an adult and needs a healthcare directive. Unfortunately, I have children, and at 18 they're still going to be my babies, but the law doesn't see it that way. So anyone over 18 should have a healthcare directive in place. Along with the healthcare directive, I haven't inserted it here, but we have also what's called a declaration or a do not resuscitate order. That would be on the same lines as the healthcare directive. Along with the healthcare documents, you also have a financial power of attorney. This is also only good while you're alive, and it names somebody to make financial decisions for you if you are unable to make them yourself. You can, I take that back, you can make the financial power of attorney valid right when you sign it. So if I signed one today and I named my sister to make healthcare financial decisions for me, I have a choice on whether it's to be good and valid right now, meaning she could go out and start signing my names to checks, get into my safe deposit box, get into my bank account, or you can make it valid only when the person signing it, when I am unable to make those decisions myself. That's what we here in Nevada, we call it a springing power of attorney. That person's power to act on your behalf only springs into effect when you can't act yourself. Most people choose that, but keep in mind if you do choose something that's effective only when you can't act yourself, you probably are going to have to get the written opinion of a doctor to say that you are unable to make those decisions for yourself before that person can act. But the financial power of attorney usually covers things like signing deeds if you're in the middle of a real estate transaction, getting into safe deposit boxes, paying bills, and I have an increasing number of clients executing these as well. Because you just don't know. You don't know if you're going to get in an accident. You don't know when the effects of your long-term illness are going to take effect where you can't make decisions for yourself or you can't act. So it's really nice to have this in place as well. Now, after you pass away, the powers set forth in the financial power of attorney would go to the person that you name in your will or your trust. And then finally, we have funding documents. We talked about funding your trust, so deeds for real property, assignments for personal property interests, such as household interests, or maybe you have an interest in a business that you want to assign to your trust. Those have to be also funded. Quitclaim deeds are just another kind of deed, and I think I just duplicated that, so I apologize about that. So in thinking about an estate plan, and I'm sure most of you have thought about it, questions you may have already asked yourself include, how will my assets be distributed when I pass away? And that's why we talk about a will and a trust. You can make plans for the manner in which your assets are going to be distributed now. And really, I tell my clients, I sell peace of mind, because once you have an estate plan in place, it's one thing you don't have to worry about. Unless you need to make changes to it, which you can, most of the documents you can amend whenever you need to. It's set, and it should be little or no maintenance on your part. And the second is, who will handle my financial decisions when I can no longer do so? Well, we just talked about this with the financial power of attorney. You can name who's going to be able to make those decisions for yourself. If you don't have any of these documents in place and something happens to where you're unable to make those decisions, in most states you're going to have a guardian appointed for you. And that's a court process where either a family member or a friend or maybe there's an office within your state that would do a public guardianship if there's nobody to act. So a guardian would do those things, take care of those matters that are set forth in the financial power of attorney for you. Who will enforce my health care decisions when I can no longer do so? You can name somebody. In fact, I always recommend that you name one person and you name an alternate in both of these documents, just in case the person you name is out of state, unavailable, passes before you do. You don't know what's going to happen. So we always in my office, try to prepare the documents so that you don't have to come back and change them later. So there's a backup. And probably most important, if there's anybody out there with minor age children, is what's going to happen to my kids. this would be the most important decision for me, and your kids are your most important asset and your most expensive, I might add. But who's going to take care of your kids when you pass away if they're still minor aged? In your will, you name a guardian for any minor children. Now, the process state to state probably differs, and this is, again, where I would urge you to ask your attorney, your estate planning attorney. But here in Nevada, when you name a guardian, that person isn't automatically appointed. They would have to petition the court to be the guardian of your minor children after you pass away. And the court would look strongly to your preferences set forth in your last will and testament as to who you wanted to be the guardian. Now, for any people out there, I'm sure there are a lot that are divorced and maybe share custody of minor children with your ex. Courts do favor parents, natural guardians. So, you know, I always tell clients they have concerns about this. Unless your ex-spouse is physically or verbally abusive, on drugs, you know, bipolar, there's something physically wrong with them, or they've harmed the children, the courts usually favor the natural parent. But you can always put a reference in your will, and I've had clients that do this, that say, under no circumstances is it my wish for the children's father or mother, whoever the other parent is, to have guardianship of them. And then it's really up to the courts. You've done all you can do. But you can definitely name alternates as well. So if I wanted my sister to raise my children, if my spouse wasn't alive, then I would say my sister, and if not my sister, then I would name someone else as a backup. We already talked about the guardianship, and then how will my estate taxes or death taxes be paid when I die? Estate tax is a federal tax. Different states may have different inheritance or death taxes, if you will. We don't here in Nevada. But you want to also have an attorney look at your overall picture, your assets, and say, what do you have? And if something happened to you today, how would your estate be taxed? Again, for estate taxes, we look at that $5 million mark, so a lot of people, that's not a concern. But you also want to look at, who is my property going to go to when I pass away, and how will that affect them? So those are also things that you need to talk to your professional estate planning attorney and your CPA with as well. Isn't a will enough? I get a lot of people who come to my office and say, I have a will, or I talk to them outside the office and tell them about the importance of estate planning, and they say, I have a will. If there's one thing that you walk away from this webinar with today, I would encourage you to acknowledge that a will requires probate. And I'll say it again, a will requires you to go through probate. A will tells the court who you want to get your property or what you want to happen with your minor children after the court process is over. But it doesn't prevent you from going through the process. Think of it this way. Like I said, if you own any property in your own name at your death, whether it be a house, a bank account, a life insurance policy with no beneficiary, anything that doesn't naturally go to maybe a joint account holder or a joint beneficiary, a beneficiary, is subject to the probate process. Here in Nevada, it's anything over $20,000. In your state, it may be something different, but you need to consult your attorney and realize that sometimes a will is enough for people. I had an elderly lady come in the other day. She lived in an apartment, and she had one bank account, and her daughter was a joint account holder. For her, I would never suggest a trust because a trust is more expensive up front, and she really didn't need one. She didn't need one because she didn't own a house in her name. She had an apartment, so she has no real estate, and the joint account that she has with her daughter, unless something happens to her and her daughter at the same time, that's automatically going to go to her daughter when she passes away. So sometimes in very rare circumstances, yes, a will is enough. But if you have any real estate or if you have multiple accounts, most people I recommend a trust for. Now, it doesn't have to be a complicated trust, but a trust that holds your property and owns your property while you're living. And keep in mind, you can still have a type of trust where you control all your property. But when you pass away, that trust doesn't pass away. That trust keeps living. And so therefore, your property doesn't need to go to probate as long as it's owned by your trust. In your trust document, you name a trustee or a manager of that property. That person is responsible for looking at your trust when you pass away and saying, oh, Susie wanted her property to be equally divided between her 3 children. So it's my job as trustee to either sell the property or divide up the property in a way where it's equally divided between the 3 of them, and the court never needs to get involved. So that's the benefit of having a trust. So is a will enough? Sometimes it is in very limited circumstances, but if you do have to go through probate, I tell everyone a minimum 6 months, minimum, and maximum probate proceedings can take over 2 years. And while the probate proceeding is occurring, that property is frozen, if you will, and your beneficiaries can't get to it. They can't get to that until the court gives them an order saying that they're entitled to that. So probate is costly. It's going to cost you definitely more than it's going to cost to set up an estate plan, which is what I tell my clients up front. And it's time-consuming. It's time, and it's hard on people. The last thing an heir or a loved one wants to go through at the same time that they're mourning somebody's loss, their loss, is a probate proceeding. They don't want to deal with the courts. So it's better to get everything done ahead of time before something happens. I get some pushback on clients that say, I already have a plan in place. I don't need one, or I don't need you to review it. I always recommend, because of changing family circumstances, changes in the laws, that your estate plan be reviewed every year. Some people say, no, I want to review it every 2 years, and that's okay. A lot of attorneys I know will send clients complimentary letters that say, it's been a year since we reviewed your estate plan or since we prepared it. Have any of the following occurred? Has there been a divorce? Maybe not even you, maybe not the person that prepared the trust, but maybe one of your children, and how does that affect the plan? Have there been any new children or grandchildren born? That's going to affect your plan. Has there been a disability, a recent disability? You have to look at the trust in those instances to see if there is a person named to take control of the trust asset. Can't manage those for him or herself. Divorce is going to affect the trust. Another interesting side note is I had a client come in probably about a year ago now. She was a single mom. She had worked for the county here, Clark County in Nevada for years, and she was divorced probably 10 years, I think, and she had a minor child. Her child was, I think she was 12. I think she was 12. And she said, I think I just need a will. Let's look at everything. So she brought in her statements, and we reviewed her life insurance. And she had quite a bit in life insurance. And she said, I think my beneficiary is my mom, but I guess we should check it. So when we checked it, her beneficiary was actually her ex-husband, who she can't stand and avoids at all costs. So she said, oh my gosh, we have to change that as soon as possible. Call right now. So I called and got the form sent to her. But that's the value in estate plan, and you don't think you need one because you have beneficiaries on everything that you own. Review those beneficiary designations. I can't tell you how many times the person that somebody is named has passed away, or they're a divorced spouse, and there's nobody else named. And if there's not a logical beneficiary named, that property will be subject to probate. Who needs an estate plan? If you want to be able to take control of what happens to your property, both during your lifetime, but mainly upon your death or your disability, and you want to avoid court involvement or attorney's fees, you need an estate plan. If you want to ensure that someone can take care of your financial decisions and medical decisions when you become unable to do so, you need an estate plan. And keep in mind, an estate plan doesn't have to be all of those documents we talked about. Maybe for you, an estate plan is just a medical power of attorney and your financial power of attorney. Or maybe it's just a will and a medical power of attorney. Every person is going to have different circumstances, and not every estate plan is right for one individual. Other benefits of having an estate plan that I probably already touched on, some of them, probate avoidance. If you have a will or a trust or a properly drafted estate plan, you're going to avoid your property having to go through probate when you pass away. Charitable giving. A lot of people want to give to charities, and the most logical way to do that is through a trust. There's a lot of different trusts that we can set up for charitable giving, and those have obvious tax benefits as well. Tax planning and avoidance. If you want to make sure that you're paying the minimum amount of tax of your estate when you pass away, you want to see an estate planning attorney and your CPA. Guardianship, this is a big one, especially for HD patients. When you get to the point where you can't handle your own affairs, your financial decisions, your medical decisions, you need to provide for somebody to do that through estate planning documents. And legacy, how do you want your property to be distributed when you pass on? What's important to you? A trust is a great vehicle to insert provisions such as, I want my kids to get my property, but college is really important to my family. So I want them to get their share of my property when they finish a 4-year degree. Give them a little incentive to finish a 4-year degree, and then they're entitled to their share of the assets. Here in Nevada, probably a lot of you will chuckle, but we put in a lot of provisions regarding addictions because there's a lot of temptation here. So I put in my trust, I ask my clients, is it okay if I put a provision in that says when the grantor passes away, when the trustee takes control of the property, if the trustee thinks that any of the beneficiaries, any of the kids or anybody who's going to get your property is dependent on drugs or alcohol or gambling, they can make them go to classes, to go to AA or to go to Gamblers Anonymous or whatever it might be, and to the point where the trustee feels that they no longer have that problem, and while they're going through those classes, the trustee holds the assets and doesn't distribute to them. Then once they're convinced that, okay, they're responsible, they no longer have the addiction problem or whatever it might be, then they can distribute those funds. Because the last thing you want to do is all of the assets that you've worked so hard your entire life to accumulate, you don't want those going to a child or maybe an heir or somebody that is just going to throw them away on drugs, alcohol, gambling, similar vices. So, and this is a very gentle subject because when people come into my office, sometimes their kids are, I don't know, between the ages of newborn and 15. And they say, oh, I can never imagine my child becoming dependent on drugs or alcohol. Well, I'll tell you what, my kids are 2 and 6, and I have that provision in my trust because you just don't know. You have no idea. And this is a way to speak from the grave. This is a way to put down your wishes and things that are important to you now so that you have peace of mind knowing that it's going to be properly carried out after something happens to you. So an estate planning checklist. Information that often helps that I inform my clients that I will need you to bring to the first meeting is family information, names and addresses of people that you want to name in specific positions, bank account statements, retirement and pension account statements, investment statements, stocks and bonds. These are all good things to gather because what I look at first when I look at these is how do you own the bank account? Is it just in your name? Is there a beneficiary? Is there a beneficiary on your retirement account? Are your investments the type where you can name a beneficiary? And that's why I ask for those. Also, basically to see what you have, to see what your assets are, because depending on the amount of your assets, I might suggest a different type of trust for you. Insurance policies, same thing. If you have life insurance, oftentimes there's beneficiaries on there and second beneficiaries, so you want to make sure those are up to date. A list of sentimental or personal possessions. I get this question a lot is, what happens to my household furniture and my jewelry and my family heirlooms, my china, my guns, whatever you have that's important to you that doesn't have a title? How do you pass that on? Well, here we have what's called a personal property list that's often stored with your will. And your will should make reference to a personal property list. Here in Nevada, we have a provision that says if those things are written down in a list and it states who those specific things are to go to, those items are given away first before anything else is. Now, the tricky part about that is It also says in the law that if those things can't be located, it's assumed that they were given away when you were still alive. So if you have a wedding ring, for instance, and you want one of your nieces to get that, and nobody can find it after you pass away, there's really not a lot of room for somebody to argue that someone stole it. I mean, they could, but it's really just assumed that you gave that away during your lifetime, which a lot of people do. But that's how personal property items are given away. If you have a trust, a lot of times we'll do a assignment of personal property to the trust. So we'll say everything you own that's personal property, furniture, photos, family heirlooms, is owned by the trust, and then your trustee gives those away in accordance with your wishes in the trust. Prenuptial or postnuptial agreements. A lot of times prenuptial and postnuptial agreements have an effect on your estate plan. So those two documents, your estate plan and any premarital agreement you have, needs to be read in conjunction so that they work together. Same thing with divorce decrees. There might be something in there that speaks to a personal item of personal property or an item of real estate or maybe a guardianship provision that we need to look at and see how does this affect your estate planning document. Any previous wills. If you execute a new will or a new trust, most, if not all of the time, those new documents will state that that takes the place of any prior document you have. So that's how those are dealt with. If there are two wills that are found at the time someone passes away, the court's going to favor the one that's signed most recent in time. Income sources and assets are also very important. What do your accounts look like now, and what are they going to look like in the future if you keep working or the constant stream of income is occurring like it is at the time that you make the appointment? And what are your assets? Trusts that you created or benefited from. Maybe you're an heir under somebody else's trust, and that could affect your estate planning documents as well. A list of debts. Debtors get paid first. Creditors get paid first before anybody else. So when you pass away, you have to pay those pesky creditors as much as we don't want to. So the amount of debt that you owe is very important too in drafting your estate planning. And a list of specific bequests. When we do wills and trusts, usually it says the remainder of my estate goes to X, Y, and Z. But before that, you can give away certain items of property to certain individuals. Very similar to the personal property list, those things are given away first before everything else. So if you want certain individuals to get something up front, you need to list that in your specific bequest section. And then tax returns. Most of the past 3 or 4 years, this depends on the attorney and what they'll ask for, but these also help. A lot of times people will forget to mention assets, and I'll catch them in the tax returns. Business interest, even if it's a small interest, that has a lot to do with your estate plan as well. And I think that Jane will probably touch on the HDSA resources at the end of the presentation, so I'm just going to briefly go over them now. There's some lunch and learns that she has listed here. She did mention some in the beginning as well. There's a guide for families available at the website for advanced directives, and then other resources. The American Bar Association is very helpful with this subject matter and can probably point you to specific attorneys in your area if you need referrals, and the ABA Guide to Wills, Trusts, and Estates. And Jane was very helpful in putting those in there for me, so I thank you. My contact information is here. I welcome questions. I am an attorney that you will be able to access quite easily by either shooting me an email or giving me a phone call. If you want to go through Jane, I'm sure that's probably okay too. Again, I can give you general information, not state specific. But if you have any questions or follow-up questions that I can't answer, or you listen to this webinar later, feel free to give me a call or an email, and I'd be happy to help. It looks like we have one question here. And the question is, if I can go ahead with that. If I can't, Jane, go ahead and interrupt me. But it looks like the question is, I live in Florida, which I'm told has a streamlined process to transfer your house to beneficiaries in your will. Therefore, some tell me there is no need to put my house in a trust. Please comment. Again, I can't comment on state-specific law for this listener. If there is a streamlined process, then you may not need to include that in your estate plan. But I caution you that there may be other assets that you need to prepare an estate plan for. So, for instance, here in Nevada, we have, what's called a transfer on death deed, and this may be something similar to Florida. I believe California has this as well, where if you only own a piece of real estate and you want to transfer that to somebody after you pass away, you can record a deed now that's called a transfer on death deed, and the property stays in your name. When you pass away, the person that you name in the deed to take it would simply go to the recorder's office with a copy of your death certificate and would transfer it into their name. So if that's what you mean by a streamlined process, yes, I know that it's available here in California. I'm not sure about your state, but that's something you definitely want to ask your estate planning attorney about.
Thank you, Brooke.
Welcome. That's the only question I see, Jane, unless there are others.
I think you just got another one.
Oh, okay. Sorry about that. Is there a good resource for finding legal help in specific states? Absolutely, the American Bar Association, as I commented on, I think there's a link in the second to last slide in the presentation. The American Bar Association is wonderful, or if you just search for the bar in your state, so for instance, if you live in Mississippi, if you go to mississippibar.org or .com, the bars in the state, in the specific states, will have resources available and will be able to point you to an attorney in your area. So hopefully that will help as well.
I think the other site that is always good for information is lawhelp.org, which is specifically for people of low and moderate incomes to help find legal aid programs. Then they might be able to refer you to other resources. We do have a little bit of time for more questions, so I want to hold on a minute. But while people type, I just want to reiterate what the HDSA resources are. As Brooke mentioned, we are coming out with a family guide series on advanced directives and Huntington's disease, which is a great place to start if you're looking for health care directives in terms of who to talk to, how to do it, where to find resources. So that's a really great resource. We've also had several webinars on advanced planning, and we're going to be doing more. Next month, we're going to be doing a webinar on financial planning, and we welcome other topics. So if there's other topics that you want to see with regard to advanced planning, you can let us know that in your evaluation. So please, if you have any more questions, do type them in. And Brooke, thank you so much. It sounds like there's a lot of things that people do need to consider, and that it does all depend on individual situations, where they are in this country, a specific situation is, but you've given us such a great broad overview.
Thank you. Yes, it's very state specific. I do have another question that came in about Medicaid that I'd like to touch on. The question is, what mechanisms are available for protecting assets from Medicaid clawback rules? And just to summarize this, I'm sure a lot of listeners have had experiences with Medicaid and qualifying for Medicaid. That's primarily an elder law attorney question, and you should consult an attorney that does both elder law and estate planning. I don't handle elder law. I often refer out to other attorneys who specialize in that. But I have gone to several seminars on it, and I know that pre-planning is very important with this. There are certain look-back rules, if that's what the question is asking regarding clawback. There's definitely look-back rules on when did you transfer assets, because oftentimes there's a certain threshold of income under which you need to be in order to qualify. And a lot of times I'll have clients come to me and say, well, it looks like mom's going to have to go into a nursing home, and what do we do to not hide her assets, but what do we do to make it so that she can qualify? And this is a whole practice area of law in which attorneys specialize in this. You definitely want to do things as far in advance as you can, so that I believe it's a 5-year rule, doesn't take effect. because they can, I'm pretty sure they can go back 5 years and see what you did with your assets. And if they believe that you transferred them so you could qualify, then they can undo those transfers from what I understand. So there are different trusts that can be prepared, but the timing is very, very important. So it's a great question. I'm sorry I can't answer it more thoroughly, but I do urge you to seek an elder law attorney in your area who would be able to assist you with that.
Thank you, Brooke. So I have another question from somebody who is watching it from the office. Is there a point when a person's will or other documents can be nullified due to their cognitive state?
Due to their what?
Due to their cognitive state, because HD often affects an individual in cognitive areas. Is there a point at which somebody's will can be nullified?
That's a great question. If it was valid when they entered into it and they knew what they were doing and they understood the ramifications and the provisions in the will, as long as they did it at that time and it was signed and met the requirements of your state, so here in Nevada it has to be witnessed by 2 people and those people have to have their signatures notarized. So as long as their requirements are met, it's a valid will and it doesn't become nullified at a date later than that just because that person's cognitive state has changed. So that's why it's so important to get it done now, and you can make changes, but once you reach that point where your cognitive abilities are not there, they're diminished, the question comes down to the notary and the witnesses, and they really have to be able to state, if they were ever called upon by a court of law, that this person was of their right mind, they were not under duress, which means nobody was twisting their arm to sign something, and they knew what they were signing and they understood it. Now, I have had clients that are in the hospital and in and out of consciousness. But when they're when they're of their right mind and they're awake, I go to them and I will present them with a will and ask them certain questions. What day is it? Do you know where you are? What are your children's names? Do you understand you're signing a will? And if the witnesses feel confident that that person knows what they're signing, they can witness it and it can be notarized and it's a valid will. Now there may be some challenges to it later, but that's why you have witnesses that are there to state that they saw the person signing it and it's their belief they knew what they were doing.
Great, thank you. So it seems like that was the last question. For everyone listening, I would first say thank you. Second of all, encourage you to please share your feedback about this webinar and about other topics that you want to hear about. And if you do have other questions that come up, you can either contact Brooke directly or contact me, Jane Kogan at jkogan@hdsa.org, and I will pass that on. And Brooke, thank you so much for that informative webinar. I can say I learned a lot, and so I'm sure everyone who is listening did as well.
Thank you, Jane. I appreciate the opportunity.
Thank you.